Trademark Office has been in DC area. They decided to, the Patent and Trademark Office decided to open a branch in Detroit. Congress thought that was a great idea and they should build on that and open more offices. So that's why we have one here now. And this is what Congress laid out for the 5 reasons that they wanted to see offices open. The first was outreach and to better connect the patent filers and innovators with the patent office. So that's why I'm sitting here today with you. The other 4 reasons were to attract, retain, improve examination, and decrease backlog. In other words, get more examiners to handle the large number of patent applications that are being filed every year. So those 4 are kind of addressed by having the office and hiring examiners. The first one really is putting someone in charge and coming out, meeting the community, and providing you information. These are the 4 locations. Of course, Alexandria is the head office. Detroit opened in a year ago, 2 years ago. Denver just opened. There will be one in Silicon Valley that opens sometime mid to end next year, and then shortly followed thereafter by Dallas.
Nice coverage.
If you look at it, we've got an office in each time zone.
Mm-hmm.
East, Central, Mountain, and West. Some of the services that we provide at the office here in Denver. So we've got some walk-in services where you can come in and get some general information from us. Most of that information is available on the websites, but if we have inventors that want to come in and see the office, and there's some information there. We have workstations for doing patent searching, like you were doing perhaps today at the library. The library in Denver, at your house?
Yeah.
Well, the library in Denver has a resource center, which has been trained by the Patent and Trademark Office. So they know how to search, and they have access to East and West publication databases that our examiners use that you can use. We have that same access in our office, but my staff's not quite as well trained as the staff at the library who've been doing it for quite a while.
Yeah, you go to the library to train. You go to the patent office, you just use it on your own.
Yeah, we have the machines. We have some basic training. You'll get a lot more training at the resource center for now. But if you already know how to do it, you can come in and use our stations too.
And it's best to call ahead to the main library to set up an appointment time. You can usually get it any time you want, but it's best to log an appointment time.
The offices have a regional focus to bring education to the area. So we, as the connection to Denver and the mountain,
we're bringing conferences or speakers and roundtables to the area. For example, next month I've got a half-a-day seminar on the first to invent. So we'll have speakers here for 4 hours, have presentations on that. Later in the month we've got a presentation on patent quality initiatives that are targeted a little bit more at the practitioners than the patent applicants. But the Denver Startup Week, I think in early September, where I've got somebody coming out from the office to talk about trademark basics, and I'm going to have him do a small roundtable at the office the following day. So we're trying to bring in speakers and presentations that normally you wouldn't have as much access to.
I was going to ask you about October 2nd, first to file.
Mm-hmm.
Is that like going to be in that second floor,
That's
bigger conference room? Okay.
And I think we just had a public announcement that came on the PTO website today.
Yeah,
so.
I've already announced it to our group, so if people are that interested, they can go.
We haven't announced, but I think it's on the 21st of October. We're having a quality roundtable, but we'll be spreading the word as we get closer to that finalized. You may not know it, but we have patent trial and appeal board judges. The patent office actually has about 200 judges right now. We've got 10 here in Denver. We'll increase that. We have space for 20 judges.
Backgrounds are pretty impressive when we were at the open house.
They're very impressive. They make me feel bad. The patent and trial and appeal board, if you file your patent application and it's rejected by the office, you can appeal that to the PTAB. So they review final rejections from the examiners. They also conduct trials on challenges to patents. And we have a hearing room in Denver. It's a little mini courtroom where we'll have hearings and have our judges participate via webcast. So it may not be something that you would take advantage of as independent vendors, but it's a resource that we've got here for the community. We also have a public interview room. So if you're working with an examiner, each one of you have different experiences in patent. So when you file a patent application, it eventually makes it to an examiner. You will study the application and apply the prior art from their searches to determine whether you're entitled to a patent or what you're claiming. Typically, that relationship or that interface is via paper. So you'll get a rejection or an office action from the Patent and Trademark Office in writing in the mail, and you will respond back within the time period. You can also call the examiner and have a telephone interview, but we have an interview room in the office where you can have a video conference with the examiners. And all of our examiners are equipped with cameras and have been told how to do this. We actually had one this week where a local attorney came in and had a video interview with the examiner who was remote. I don't remember what state they were in, but it will provide a resource to allow you as an applicant or the attorney to hopefully speed up the prosecution of the case. I always found it better to have a face-to-face. If you can't do that, then at least have a telephone. But a lot of our examiners, English is not necessarily the primary language, so sometimes the phone conversations are a little bit difficult.
Mm-hmm.
So I think the face-to-face helps a lot.
Especially if you have if you have a nice prototype, you can take the real invention in and show them.
Yeah.
That's a real benefit of it.
I mean, it's a video conference, so you can share, you can demonstrate, you can have a discussion. The examiners can share their computer screen as they're working, so they can show you their drawing or their prior art and have a one other thing that we have is the capability to do training for our examiners. We like to train our examiners in technology to keep them abreast of newest technology. So what we've done for a long time, and I participated when I ran the operation at Micron, I would take some of my senior engineers and fly them to Washington and have them give an hour presentation to a room full of examiners. But it was very expensive to pull them away from work, take them away for 2 days to fly to DC. The regional offices have the ability, we can bring in experts and webcast that, telecast that out to all of our examiners. So we want to take advantage of that to improve the quality of our examinations. Some of the workshops that we have done and are continuing to do, we'll do a lot of K through 12 and IP professional training. So we actually have a lot of work with a company, organization called Invent Now to provide. This was kind of fun. I did this last month. It was just grade school kids and have a whole week of inventing, explaining to them, letting them explore, letting them create things, and just getting the idea of they can tear things apart, build things. So we work with a lot of that to promote innovation and promote thinking about it. And it goes from K-12 and it goes up to all levels of the college. Our basic facts, I kind of touched on a lot of this, inventor conferences, focusing on startups. So these are some of the things that we're bringing in. We're going to work on putting a one-on-one program in. And you used to be able to go to Alexandria and literally just walk into the building and talk to examiners, and they would help you do searches and stuff. With the security systems that are in place now, that's become difficult. I'm going to try to bring that back a little here. Regionally, get a few of my examiners to volunteer so we could have, a set time periodically where inventors could come in and have a discussion with an examiner.
Yeah, that's how I learned to search. They told me go to the patent office and hang out for a week. And but there was a lot of searchers there too. But you could go up to the examiners' rooms, and that before the internet, they had their own file, paper file, that was just their technology. It was a big help.
Some of the programs that we've got that are designed to work with startups and increase the awareness of intellectual property, help them identify the risk of early public disclosure, and you kind of touched on it, Bonnie, that there are legal requirements both in the U.S. and internationally on when you have to file your patent application based on offers for sale and public disclosures. So we used to be a first to invent system. We switched with the American Invents Act to a first inventor to file. So the differences are that there used to be a more defined grace period on when you invented and when you had to file an application, and now it's a little bit different. So I won't get into the details of it, but those are some of the education we bring, including that seminar that we're going to have next month. Maybe something interesting for this group is crowdfunding campaigns. That hasn't been, there's no precedent yet from any courts on whether going to a crowdfund to get investment money is an offer for sale of your invention. So it's something to think about if you're going to use a crowdfunding. Because we don't know yet.
But it's also a disclosure.
It depends. It could be if it's viewed as just getting invested in. See, a lot of crowdfunding, they put their idea out. It may be very generic, but one thing that they say is, well, once we get this product developed, you'll get one as part of your. So it could be confused. It could get into an offer for sale of the product as opposed to offering you to invest in my company. So there's some nuances to that. I just wanted to throw it out because if you decide that you want to try that,
A lot of people like to.
think about whether you should have any protection before you go into that. You can go to USPTO.gov is our main website. If you go to USPTO.gov, there's an IP awareness. It's basically a test. So when you go to the front page, you can go to the IP awareness tool and we'll kind of walk you through and see how aware you are of the different kinds of intellectual property. And at the end, it will kind of present some recommendations to you for where to get additional information on areas that it appears that you're a little bit weak in. So feel free to, it takes a little bit of time, but it's worth going through it.
And now, would you say that for that link and that little test is more for the inventor as opposed to
Yes.
a patent?
Yeah. It's more for a startup company. It's more for early exposure to patents. And it's not a test of patent attorneys or anything like that.
Okay.
Can I ask, what is it, 1 year from the time you offer it for sale or disclose it publicly that you have to file for patent protection? Is that like the general rule of thumb?
You used to have a grace period where you could claim priority back to your first disclosure. And that was under the first two in bed. Now we're under the first file. You have, I'm not here to give counsel, so I have to be careful. But what you do have, there's, the rest of the world had a first to file. And we kind of harmonized with the rest of the world, but we're slightly different. Congress called it the first inventor to file, meaning that if you make a disclosure and somebody else learns of that and files a patent application before you, and then you file, that you could predate them or invalidate theirs. So, in other words, I shared my idea with you, you went and filed the application before I got my application in, then I got a procedure that I can work through to.
And you kind of technically claimed you were the inventor and didn't tell me, so that's another problem.
But if you lose international rights if you disclose to the public before you file. So, and that was the same before. The U.S.'s grace period was not recognized with first file systems around the world.
You lose international rights if you disclose to the public before you file.
Before you file that application, yes. So relying on any grace period is a risk.
It's kind of risky as a business strategy too, because if you disclose and then you file in 6, 8, 10 months, and someone files ahead of you, I mean, it's an issue you have to deal with, and you just do not have to deal with it. And plus, you keep your foreign rights.
Is it for both utility and design patents?
Anything.
You can also sign. We have an online publication called the Inventor's Eye. So you can go to our website and sign up for this. And when you click on and sign up for it, which I just did this week myself, we also provide a lot of other buttons you can press. So the patent office will push to you not just the Inventor's Eye, but also any notifications that we've got on upcoming seminars, news releases, so on and so on. We're not picking, but it's a good way to, instead of having to go to our website all the time for the latest updates that come to your email, the Inventor's Eye is kind of focused on some education and some information about new inventors and highlights on inventors. So it's also, I think it's a nice resource.
We have a link on our site to it and our emails, plus our organizations and the list of organizations.
I don't know if you know pro bono program, but let's see if I got it. Yeah, the pro bono program is relatively new. It kind of started, I believe, up in Minneapolis, and the American Vets Act wanted the Patent and Trademark Office to work with different associations to build out the pro bono program. So this is a resource I think is very important for single inventors, small inventors to take a look at, because there is a pro bono program here in Denver. So it's a way to get free legal help in advancing your.
Talk about your experience.
Oh, no.
Teresa's used it.
Well, I'm still, but they still have to file something. But I'm just kind of waiting, and I thought I'm going to try to do something pro se myself.
Okay.
I'm waiting. Because I also have another convention, like once you start, your brain just starts like coming up with more ideas. So I thought, okay, I can do this myself since I'm learning as I'm watching counsel.
Well, we also get pro se assistants in the office and working on finding ways to help pro se applicants it's a program I'm not quite ready to talk about, not because it's not ready to be talked about, but I don't know enough about it yet. I've only been on the job a month, so. Law school clinical programs a little bit different than the pro bono, but we've worked with a lot of law schools around the country that have students that want to start helping the community. So these are recertified the programs with different universities where they're supervised by usually outside attorneys that basically they're interns that are volunteering their time to help out. So, and we have some in Colorado and spread around the country. So there's a lot more information about that too.
Are you working with one particular university here or multiple?
I'm not sure which universities in Colorado have been approved. I'm sorry.
That's okay.
I will. It's all listed. I know we've got them here in Denver, but I'm not sure which one of the law schools. If multiple ones have been approved. So, we talked a little about the Patent and Trademark Research Center. We have one in the public library, so I won't spend any time talking about this, but it's a great way to. They'll also provide you basic understandings of intellectual property and the differences between patents and trademarks and stuff like that. The patent office is always classified inventions according to their classification system. We're working on a cooperative patent classification system to harmonize the U.S. with the European Patent Office and others so that we are talking the same language on technology. So if your technology, and what I mean by classified, it's a very detailed organization of semiconductor processing, chemistry. So the classification code identifies the technology area that your invention applies to. And when you've got different patent offices around the world using different classifications, it's very hard to have a common search between the different offices. So we're trying to harmonize that so that if your invention is classified in the U.S. matches the classification in the other countries, whether you're filed or not, at least the same part that's being applied is fairly consistent. Micro entity, this would apply to everybody in the room. As you apply for a patent application, the prices are different. If you're a small inventor, which was classified as under 500 employees, your rates were half of what a large entity was. So when I worked for the industries, we paid the large entity fees, and there's a small, but now there's a micro entity fee. As long as you haven't been named on more than 4 patents, and your household income is no more than 3 times the median household income, which is set by Congress or whatever, so I'm not sure exactly what that number is. You haven't assigned or granted or obligated to assign your patent to somebody that's not, to somebody else basically that would move you in a different category, your rates are really cheap. So look at that if you're going to be filing, whether you're filing pro se or with an attorney, that you probably qualify under the micro entity status. So it becomes much more cost effective to.
I might mention on that 4 patent rule, they're pretty nice because provisionals don't count against you. Foreign don't count. Patents you're named on while working for someone don't count. So it's only U.S. utilities filed in your name as an individual that count against the 4. But if you're partnered or you got a joint inventor that has got money, not sure. So
and as being a co-inventor and assigning your rights, also counts
They
against you, right?
count, yeah.
I'm gonna walk through some of the initiatives based on the timing of applications. So prior to examination, during examination, after close of prosecution. The examination process is referred to as prosecution. So just below the nomenclature. If your application is finally rejected by the patent office, then you've got the ability, as I mentioned earlier, to appeal that. So there's a notice of appeal process you could go through. And then should you get the allowance of payment of issue fees. So these are some of the different phases, if you will, as you go through the process. And we've got some different initiatives and programs that we've created over the years to work with applicants during those. So tools prior to examination. We have what's called the Track 1 Prioritized Examination, which your patent application, if it followed the normal queue, would take probably on average 3+ years to get to a final decision. So it might sit there for a year to a year and a half before you hear back from the patent office. It depends on the technology area. Some of the technology areas are running fairly decent steady state, so you would probably get a first action in 12 months. Others are 3 or 4 years. So on average, it is out. The Track 1 Prioritized Examination guarantees that you'll get to a final action, final resolution within 12 months. But it costs you a lot of money to do that. So the Patent Office provides this opportunity, but it's very expensive to go that route compared to a normal examination. The reason is the Patent Office is set up special resources, and to cover the cost of those, they charge more. Does anybody have any experience with that?
Just the other program, the accelerated exam, the petition, is that still in?
Yeah, petition and make special is still available.
Because I was thinking, I guess, yeah, they're structured differently. So Track 1, you just pay more money, and accelerated, you do what I call a super search on your own, and then provide an examiner's analysis to review.
Yeah, that's different. The prioritized Track 1, you are limited on the number of claims that you can file, but you don't have to do any search or explanation of the case. First action interview pilot program is put in place so you can have a full interview with the examiner on your first office action. The global patent prosecution highways are, I don't know if I get details. That was put together so that if you're filing internationally, you can use the examination from one office to accelerate the examination in another office, and that's kind of a simplistic statement on it, but it's if we can get all of our offices, the major offices, harmonized, there's no reason why an examination should have to be done in the U.S. and in Korea and in Japan and in EP. If we all have access to the same art and are applying the same standards, then one examination should be enough. So the prosecution highway is the first steps to trying to make it easy for applicants to get patents internationally. The glossary pilot program is one we just kicked off, and it's mainly focused on the software arts, but it was pushed forward by President Obama to voluntarily include glossaries in the patent application to provide more clarity and certainty in what is being claimed in it. So that's a new program that's just recently kicked off. Ombudsman program, if you run into some issues with examiners and prosecution, there is an ombudsman program in the patent office that you go to help get things resolved, if you will. So I was telling you, the track one is expensive. The fees are, depending on your size, $4,000, $2,000, or $1,000. That's just extra money that you pay. I've done it both for myself and for my corporation. It's expensive, but it feels good to have an answer really quick by the patent office. So if you're in a hurry to find out what your likelihood, for example, if you've got a startup and you can afford to do it because you really need an answer to get some funding, this is one way to get an answer within months.
Now, do people who are over the age of 65, do they come under this track one, or is that a different program?
No, you're thinking of the petition to make special,
Right.
which you would still go through the queue and you still put the petition in. If the petition is granted, then they push your application to the front of the queue, but there's no guarantee on how long that takes. It's to make it special because they realize either because it's being
You're just ahead of the non-specials. There's no time guarantee.
Yeah.
But there's no cost.
Oh, okay.
So.
Yeah. The track one is, 1,000 for micro entities, 2,000 for a small entity, and 4,000 for a large entity. No more than 4 independent claims, no more than 30 claims. But you will get an action within months, and you'll have a final within a year resolution. And so that
Could be worth it.
well, it is if you look at track one, total pendency, and let's see here. Well, you can see how much faster the track one is versus your normal prosecution, which might take up to 30 months. We are done in 12 months.
I have worked with a couple individuals, directly and indirectly, who were over the age of 65, and it's true too. Those came back within 6 months.
Wow, that's
they were
great.
published, and yeah, there's a real consideration there.
So I touched on these. The first action in a pilot program, you need to file a petition, but you have a full you'll have a full interview with your examiner before the action. So you can see that the allowance rate goes up dramatically when you have that interview. So it gets everybody on the same page. It gets the examiner to understand the invention better than just reading it. And it also helps get the applicants, I guess, a little bit in line with where the examiner is on the case. So the first action allowance rate is 30% versus 11%. So getting an issuance early is possible by using the interview program. These are just slides backing up patent prosecution. I've used this a lot in the corporate world where we get an allowance in one country and we'll use that basis to get
We've had inventors ask, it's cheaper to get one in a foreign country, why not file for an international patent? And let it come back for a U.S. patent.
It's the United States. I did that in the United States for 1 year for getting it.
Oh yeah.
Opinion. I went back to the United States and got my invention and got a patent out. I beat the book my patent office.
What are the downsides of that that you're aware of?
To what?
To filing for an international patent versus a U.S. patent?
Well, a patent is only good in the country that it's issued in. So jurisdictional. So if you get a patent in South Korea, it's only good in South Korea. You get a patent in the U.S., it's only good in the U.S. So if you have needs for having patent protection in a foreign jurisdiction, then you your strategy is to go to a country that you don't really care about, get a patent, and then use that, you're spending a lot of money. It's the downside. So,
Yeah, I don't think it would ever make sense because a patent outside the United States is going to cost you more because their filing fees. In the U.S., the filing fees are subsidized. They make it up in maintenance fees. Like you go to PCT, your filing fees are going to be $4,000, $5,000, $6,000, $7,000, not $400 to $700. And plus, they hit you up for annual annuities even while you're pending.
It's interesting because we've had inventors discuss doing that, thinking they're going to get out cheaper.
And then the other problem is if you file overseas first, you have to get a foreign export license from the patent office. So you got to pay extra for that. You can't file a technology outside the U.S. without an export license. If you file a U.S. patent first, they do it for you automatically, and it's included. So that can be a pain.
Depending on the country, you'll probably need you may need a local agent. You'll probably need translation depending on what country you go.
Yeah.
So the fees, the cost of going international drive up the cost of protection exponentially depending on how many countries and which way you want to go. If you file directly at the country or go through the PCT process, I used to say if I budgeted $10,000 for filing a patent in the U.S., then I'd have to budget $50,000 to $100,000 to do it internationally. So, and that's for a large company, but the point is it goes up considerably to get that. So there's usually not a good strategy to file foreign and then U.S. unless you really needed that protection. I talked about the pilot program, so this just started in June. It is to, in response to the White House executive action this past year, to try to address issues with software patents that the public has been having issues with as far as what you might have read the news about patent trolls, etc. So this is trying to develop a strategy to get more clarity in patent applications.
It's only for software patent applications. Is that right?
I think you can do it for. The patent office doesn't really say, well, this is a software, this isn't a software. So I believe that the initiative is open for pretty much anybody. But the point is to try to address what a lot of the public has had problems with understanding the different technical terms that are constantly being included in patents in some of these technology areas. So if you're doing mechanical, there's really not much need for that kind of a glossary because it's fairly.
It's a good idea.
It's a glossary, a table of contents, an index, definition.
It's like your own dictionary.
You've always been able to do that. If you go to the website and take a look at this link, it'll give more information about exactly what they want to see in it. So, you asked a couple questions earlier. So, during examination, some of the things that are available to you are the petition to make special. The Ombudsman program. The petition to make special it's always been around, so that's over 65, or if you document that there's an infringement. What are the other categories?
The inventor's terminal,
Yeah. So the point is,
and then certain technologies, environmental, cancer and AIDS cures, there's certain technology classifications that come in.
So for the public benefit to expedite it, or the inventor, there's a need to get an answer because of being sick or etc. So, but that's a petition. You file a petition if it's granted, and the case moves forward faster. The Ombudsman program, which I've got a slide to. The general interview practice, which I touched on, that you can come to the office and have an interview, video interview. You can always have an interview over the phone, so all of our examiners are highly encouraged to respond to the applicant and schedule a time to talk. An IDS is an information disclosure statement. It's a way of putting forth in front of the patent office art that you know of. And so, let's see if I got a slide on that one. So the Patent Ombudsman Program enhances the office representation, if you will, with the applicant. So we're trying to provide a way in which, if you're having a bad experience with the patent office, we've got somebody there to try to help that. A lot of applicants have felt like they don't have a way of expressing to the patent office without fear that somehow their patent application is going to be tainted.
Yeah.
So, it's not the same as it used to be. Absolutely. This graph just shows over time from 2008 to 13 the relative number of hours that are being logged for examiners spending time on interviews with applicants. So you can see that it is a push for the patent office to continue to make time to talk to the applicants instead of just working off the paper. So it's a dedicated way of trying to improve the quality in the, if you will, the service to them. And speed up.
Communication.
It helps not only the applicant, but it helps the office because we're trying to get it backlogged down. If we can find a way to get to the proper scope for a claim and get a patent issued, it helps you and it helps us. So that's the WebEx and our public interview. Let me stop and just take some questions, if you will, before I've got a few more slides on here, but gives me a break from talking and hear what you guys are saying.
This is your time, guys. This is so rare about you. We don't do that kind of stuff.
I'm in here in Boise. I wear jeans and t-shirts all the time, but I'm getting to know Colorado, so.
I'm just kidding.
That's okay.
I'm just kidding.
No questions?
I think one of the frustrating things for people in the patenting process or inventing is the number of cases that get denied.
Mm-hmm.
You have an infringement, you take to litigations, it's absolutely outrageously expensive to go to litigation. And then to have only 24% successful in that litigation is pretty discouraging. If I go someplace and I buy a product and it doesn't function the way I expect it to function, I can take it back, get my money back.
Mm-hmm.
Okay? I think the patent office ought to have some insurance on the patents they issue.
Mm-hmm.
Because if you're issuing patents and I get sued, and because I'm a small entity, some big guy railroads me with their law firm, and I've had this happen already, they end up giving up rather than maintaining their ground, standing their ground, and actually maintaining the patent rights. You understand what I'm saying?
I understand.
And it's the bully principle, you might say. And I would think that the patent office, it would be great, I mean, in an ideal world, that they carry insurance, especially for small entities. Say, okay, if you get infringed, we're going to stand behind the work we do as a patent office, and we're going to take care of it for you. I know, that's kind of pushing.
I'm just listening.
Right?
Listening, yes.
But I think that you have more inventors willing to be creative and go forward with patenting if they're confident once they get that patent that some big bully isn't going to come and outspend them with their attorneys and
Well,
invalidate their patent.
it's an interesting concept. I don't know how it would actually work out.
Me neither, but I'm just saying.
I would think that the cost then to get a patent would be hundreds of thousands of dollars to ensure that it is absolutely bulletproof and could not be invalidated in litigation, which would make getting patent completely prohibitive. Because the cost, as you say, of litigation is in the millions of dollars to enforce your patent, and it takes many years of litigation to get to a final resolution. Which is one thing that the Patent Office is dealing with right now with the Patent Trial and Appeal Boards is the procedure that was created by Congress to come back to the Patent Office and challenge patents instead of going to federal courts and fighting it out there. You go to the Patent Office and within 12 months have an answer whether that patent that they already issued is or is not valid. It doesn't address what you're
Yeah, I mean, it's a positive step, the post-grant review.
Yes.
It's expanded re-examination, so you can challenge patents at the patent office, and that's an expanded coverage thing, and not have to go into court over it. But the other part of it is infringement itself, assuming, say, the claims are solid. And, that's where the economics are just so bad on a smaller volume product.
And as a consequence of that, a lot of inventors will say, well, why should I even bother with the patenting process? I'm just going to run like this.
Well, it can give you licensing opportunities.
Right. But then you have to get it on the market to really have a viable chance.
Right, you got to have some commercial success initially to make the patent worth anything.
Right. So you can't hear where I'm coming from because I've been doing this with inventors for so long.
Well, I think,
hearing them get taken, I mean, one of them I worked with, their retailer infringed on their product after having it on the shelves for 18 years.
There's two issues that you're dealing with. One would be an infringer of a valid patent. So if you have a valid patent and somebody's infringing, enforcing that, in other words, kicking them off of your land for trespassing, really has less to do with the patent and more to do with the litigation process.
That's true.
Having a patent that you're trying to enforce that ultimately becomes invalidated, whether it's because the court or the Supreme Court has changed the law and said that now this category of technology is an abstract idea that's not patentable, and so your patent becomes invalidated, like a lot of software patents or business method patents have become, or a piece of prior art that the patent office hadn't seen, you hadn't seen, was presented to the court, and the judge and jury decides that your patent is, in fact, invalid. It should never have issued because had that piece of art been in front of the examiner, it would not have issued. Those are two different ways that, a small inventor or a large inventor, for that matter, could end up losing a lot of money, a lot of time, possibly the business. I understand what you're saying. It's an interesting concept. I'm happy to share it. I just don't know that. I'm very confident that Congress would not pass a law to say that if you lose, if they did, they would say you get your money back, which wouldn't cover the cost of the litigation. So,
No, just there must be something that could be done to encourage the creativeness in going for a patent. If you know that once it's issued, then the patent office will stand behind it.
We'll stand behind.
You have the presumption of validity, but
Yeah.
When you go in, and you can never, we could never resolve the David and Goliath issue between,
That's the problem.
For example, I was reading on the news article this week talking about a case that Intel was just fighting, and then they were asking, they had won the case in patent infringement, and they asked for $9 million in attorney's fees to cover the cost. So they spent $9 million to litigate, and you're never going to solve that if you're small versus large. I will say I've known a lot of good success stories with small inventors. The patent office has a lot of great stories of inventors that we've worked with and helped with some of the programs that are in place, and they've been very successful. So it doesn't happen all the time. It depends on what sandbox you're playing in. If you want to try to get Intel or Google to follow your patent, it's going to be very difficult. But I'm getting outside of the patent office presentation, so
yeah. No, it's just an issue that.
This is a toolkit that we provide online, and it's a little bit different on the litigation side. This is if you've got a small business and you get a notice letter from somebody. We do have some information we provide about what to do, how to handle it. It's not legal advice, but it's just some frequently asked questions advice that it's help you understand. Because we get a lot of inquiries if somebody gets a letter saying, hey, you're faxing and you're infringing this, and they want the patent office to help them explain it to them. We work very hard internationally to help stop fake products. So we've got some tools and resources to help provide some information to the public about. You usually see something like this coming out of China, etc. So copying your products. So we provide a lot of information on our website for that. The patent office isn't just in the U.S. We are in the U.S., but we have IP attachés that are in quite a few different countries. The reason we have them there is to try to help improve the IP systems in those countries and help harmonize it with the U.S. so that U.S. companies that seek protection in those countries have stronger rights, better represented. So the patent office is the outreach program for that. And I think that gets me to the end of my what we have to offer and what you can find on our website. And actually, it's really more of an explanation of IP. Where are we on time?
It's almost 8, so yeah, it's good.
Okay.
We could open up the rest for Q&A.
Questions and answers. Anything of Russ? Or?
That question, how's your outreach program working in China?
Well, it actually is working very well. The Chinese patent system and judicial system is really come along a long way in the last 10 years. I would go to China every other year and meet with sometimes with our attaché at the embassy, with the People's High Court, which oversees the patents, go to the Patent and Trademark Office in China and meet with a lot of companies. So I would do that as part of the program that we had for an organization that I belong to. And I can say that it's a big country, and each court spread out around tends to operate a little bit differently. You get to a large city like Beijing, and it operates very similar to the U.S. They're very educated. They understand the importance of intellectual property. Their enforcement is getting better. And all the U.S. governments work very hard over the years to help with that. So, doesn't mean that there's not a lot of infringement that goes on.
Understood. It's getting better.
It's getting better, and the U.S. government is working hard with China and others to make sure we have strong trade secret protection there and stopping the fakes. So, definitely improving.
I have a question. In my little search today, I found a lot that people hadn't paid their maintenance fees, and so their patent was expired.
Mhm.
So does that mean it's as if they never even filed, or can someone take that idea, or do they resubmit, or what happens?
When a patent is expired, either because it's expired its natural life, or the maintenance fee has been paid and it's been expired, it's dedicated to the public. It's
Nobody else's.
it's not a protected patent anymore. The patent is
You're free to use it.
yes.
Although you can't patent what's there because it's public domain.
Got it. It turns into public domain.
But they're subject to revival.
Yeah, I know I'm getting it. But so there are ways in which if you forgot to pay your maintenance fee, you could revive it. You could petition, explain that it was an accident that you forgot to pay it. But somebody with intervening rights wouldn't. So if you saw that it was expired and you invested money and started producing it, then you were infringing during that time frame. You got some rights to continue, but at that point, I'd send you to where to help. But if expired patents mean that it's free for you to exploit or use because you're not going to get charged for the infringement by everybody. As far as prior art goes, it was prior art based on when it was first published and first available. So from that standpoint, it goes in. It's Roger said it's been in the public domain as far as known before it ever expired. But once it expired, then it's kind of free space for you. That's the whole reason there's a patent system. Our founding fathers built it right into the Constitution. Article 1, Section 8 of the Constitution as the basis for our intellectual property protection in the U.S. To promote science and the useful arts, Congress can grant exclusive rights to inventors and artists. So you've got your copyright and you've got your patents in there. The idea was that if you, and this obviously when the country was formed, communication was not as open as it is now. If you had an invention, they felt it was better to disclose it to the public, give you exclusive rights for a period of time, so that others could take your idea and build on it. That's the whole reason why a patent exists in the first place, is to get the creative arts moving forward instead of everybody doing it secret in their lab and then somebody taking years to figure out what they did when they could be building on it now. But that exclusive right ends, and then the rest of the world can use that.
Use it. That seems like a much cheaper way to go. Quicker and cheaper. Somebody's idea that is perfectly fine, but their patent is expired. I can just make that.
Mm-hmm.
I'm glad I showed up today.
Well, that's it.
The only trouble is everyone else can do what you're doing.
That's fine.
So you have no exclusivity.
But that is the key, because a lot of times people think that getting a patent
I know.
is the end all.
They think their world is going to magically get better.
And really, the payoff is in the commercialization.
Exactly. Yeah, actually, in this whole stack, only one of the gizmos I found that has a patent on it is actually being sold. One out of like 200.
Yeah.
Right.
That's the norm.
It runs 1 to 2%.
No.
1 to 2%.
Really? Wow.
Are out in the market.
Yeah.
I would offer that based on my experience. I came from R&D background. I had careers and had our own little entrepreneurial thing. We did the patent, the international patent. We looked back and kind of do an autopsy on it because it fell through. And we're of the belief today, especially with the communication being so rampant and the infringing offshore being so rampant, if you got an idea, just run with it.
Just do it anyway.
Yeah, because if you keep it domestically here, you got a better chance of protecting it. But if you send it outside to China or somewhere, they're gonna go, oh, pretty sweet idea, and off it goes. So that's our current view now. Take it, develop it, brand it, and then just run with it, and then have the next idea right on your heel.
Yeah, certainly. I mean, there's certainly advantages.
It's like Depends on what you do.
Yeah, depending on the strategy. So as a small inventor, having some protection when you go talk to somebody to develop or to partner with the market, it's important to have some protection. And it's important for both parties. I mean, if you're a small inventor and you're working with a larger group, having that documented protection up front provides you a safe harbor if they say, no thank you, and then they do it anyway. But it also, if you're looking for venture funding or investment, to have some IP that's instead of just take it and run approach. So depending on the kind of company and where you are, each of these strategies are different.
The apples and Googles that you have to run make sense, but if you're a small person and someone infringes, like you pointed out, do you have the money to go and litigate this?
They start at $600,000.
Yeah, so people just don't, I can't win that one, so I'll just move on.
Yeah, I've had, my experience was slightly different. I had a patent that invention I filed on, I got a patent many years ago, and determined that it was outside of my ability to create a company and so I licensed the patent to another company. So there are opportunities in which you can take your intellectual property and protect it and exploit it. Not everything's going to work. Sometimes you'll have bad partners who'll take your idea.
All sorts of,
other times people will infringe and say, well, do something about it. No different than if you had a nice piece of beachfront property and you put a sign on it, private beach stay off, and you look out the window and there's a bunch of people and you tell them to leave and they say, make me. There's always instances where it becomes difficult. And then you try to kick them off and then they go find out that actually the 15 feet on the edge of the water is public space and I didn't know it. So without going down the path, I mean, intellectual property is no different. It's a right, and you have to enforce it. So sometimes maybe it's a good strategy if you're quickly innovating and moving products that you hit the market and go.
So you said it depends on your sandbox.
Yeah.
Well, and if you're looking for investors, as Russ pointed out, and I've done presentations to investors groups, and they won't usually touch it if it doesn't have some intellectual property capability with it.
Yeah, you can always debate the value of the patent, but generally you're better off with one than without one.
That's right.
Whatever it is, yeah.
Time consuming to get one.
But
Well, not really. It takes a long time to launch a product, and
the cost of a patent is minor.
yeah, like 1 to 10% of what it takes to launch a business. And you'll use that time. You'll like the long pendency usually, because by the time you get your manufacturing going and get it promoted and start getting it sold, it's going to take a few years.
No, this is very kitchen table level manufacturing.
Well, and there's another way of looking at it. There's another way of looking at it, Nancy. And that is that if there's somebody that has patented something out there already that is basically your product, you can approach them and have them assign that patent to you, maybe pay them to do so.
Yeah, or license
it. Commercialize it. And then you have that patent protection because it's been assigned to you.
Well, the other thing I saw was a lot of people were going back and referencing, patents from 1910, 1920, and then they have a design patent on their ornamental version of the exact same thing. So is that a cheaper process, a quicker process to go through to get the design patent instead of a utility patent?
It's much narrower protection. It's protecting surface ornamentality and not the function. You can certainly put both patents on one product. Like the iPhone, for instance, you have utility patents on the inside, and you might do design patents on the casing and its appearance, and also trademarks on that too, and copyrights.
And on this slide, if I had gotten into some of it, what kind of IP is maybe on that particular product, including the trademarks for the product, design patents, utility patents, copyrights, and ones on the trade secrets in it. So there's a lot of different intellectual property on different products. design patents are limited to, bless you, the ornamental aspects of a design, so non-utilitarian. So as Roger said, you could get an industrial, basically protecting industrial design versus the utility.
Okay. And it's the same amount of time to process the design?
No, I mean, a design patent is much cheaper. Your protection is in some terms narrower because it is the design, but I mean, Apple's been successful recently in getting some pretty, I think it was close to $1 billion initial decision against Samsung, so there are strengths to design patents. But it depends on, it really depends on what you've got, which is the right.
It's what you're known to the market as, that's what you want to protect. Because you don't want people knocking that off from you.
Well, one of the things you need to be a little cautious about too is that there are companies out there that are less than reputable, and they will give you a design patent when it should have been a utility. And then when you find out, and you go to file for a utility, you find out that your design patent is prior art and you can't get it.
I didn't quite follow. So
you guys explain it.
The proper protection for some inventions is a utility patent. It covers the utilitarian features of your invention. If you go to some less than reputable marketing companies and say, we'll get a patent for $500, what they get you is a design patent where they just had to file some drawings of your product. If then you figured out that they scammed you and you went and wanted to get a utility patent, you may not be able to because what you already filed became prior art, and perhaps it showed the feature that you wanted to claim.
Oh, okay. I see.
So
they count on
That's right. These things hover in space, like if nothing attaches, like the ones that are design patents show literally nothing.
It's just drawings and then
Yeah.
they're lines and they're just explaining.
Yeah, I mean, they float in space, like, yeah, how's that gonna work?
Well,
So, because they don't wanna mess themselves up, or infringe
well,
on
they
someone else's
count on
utility.
you not knowing. Like, oh, I'm getting a patent. That's all the person.
Yeah, we're confusing two different topics. When you do look at a design patent, and you just see drawings and you're thinking,
It's hanging in space, yeah.
all the protection is on those solid lines, on the ornamental features of that. So they don't have to show you the rest of it or explain how it works because that's not what the patent covers. The patent literally covers the shape and the industrial design of your creativity.
So there could have been a patent filed on that bottle.
Yeah.
One Valley probably was. History, yeah.
But it seems like what people are doing, at least with this type of gizmo that I'm talking about, is they're getting around having to go through the bigger utility patent, and they're just getting the design patent. It seems.
The function of your gizmo may be old. And you were saying
It
about
is.
something.
Yeah.
The function
Oh,
of
you
old
can get it.
probably isn't patentable under utility because it's well known. But same as a bottle. A bottle is well known. You can't patent the utility of something to hold a liquid. But you can get design patents on
So that's
lots of different shapes of bottles that you create today. So depending on your invention.
Yeah. Well, would how something attaches be enough of a difference?
Perhaps.
So that's why
Good, but I think your best bet is don't go for a design patent just because it's cheaper. That's the big caution. Talk to an attorney and find out what is the best route for this particular product. If you can get a utility, get that first.
That's the power.
Don't go for a design if you can get a utility.
The reason utility is stronger is because it tends to stake out a larger area for you of protection. So if you've got a unique way of connecting, there's perhaps a lot of variations on that you could claim and have all of them. So the design patent is limited to what you've shown and a little gray space around that. A word of caution design patents is don't discount them. With 3D scanning and 3D printing, it's very easy to have your ornamental designs copied now. Much easier than having to go have a mold maker, spend $5,000 to make an injection mold and start making. They literally can print them around the corner in a 3D shop. So I think design patents will actually see them become stronger in the next 5 to 10 years. So don't discount it if you've got neat little part.
And would you guys agree too? I mean, it just depends. Where's the power in your IP? Is it in the ornamental appearance, or is it in the utility? Is it company?
It depends on the product, you know.
Exactly.
But what's important to your commercial success, which is something you can say that imputes, it's what your competitors want. That's what you need to protect.
That's a good point.
And that's how we would look at, like, what do you claim in a patent? Because you can throw in tons of detail, but really, what you want is a feature the competitor has to have to succeed. But I might also add, whatever you design patent, you can most likely copyright and trademark the same thing. So that gives you some different angles on protection.
Yeah, and here's kind of an overview, very briefly, of the kinds of intellectual property protection. So utility patent covers what we typically think of as inventions. It's good for 20 years from the date that you file it. Design patent is for non-functional ornamental aspects, like the shape of a guitar, design of a lamp. That's good for 14 years. Copyrights are good for the life of the author plus 70 years. So 70 years after you die, your copyright is still enforceable. Trade secrets are good as long as you keep it secret according to the statutes. So if you protect it and keep it confidential, it has its protections. Trademarks are old as man. It's a way of marking your goods so that people know where they came from. So take that antique and look at the bottom of it. It's got the mark on it. So that's the origin of what a trademark is. So trademarks cover products in commerce in a way of marking them so people know. And they cover a lot of interesting things, whether it's a color or a sound. But in any event, the trademarks can be a very valuable piece of IP for your business if you've got a unique. If you build I hate to say build a name for yourself, but that's the point, is that there can be a lot of value in those two. So those are the basics of different protections that are available. And Roger said you can use all of them, just like in that cell phone example. They're all available.
It's a great show. Is that on the USBTO side, or is that a Russ original?
I'm not taking credit because all of these slides were approved by the office. All of the information. I mean, copyrights are for the Library of Congress. They're not technically for the Patent and Trademark Office. And trade secrets, there's no formal way. So this information, I don't know that this information's on the website.
That'd be a great handout for inventors. That's what I'm thinking.
Except there's no prices on them, that's
What are the prices for the utility and design filings?
Oh,
Like you had mentioned, the asphalt prices.
Roger, are you familiar with the current fee charts?
Oh, yeah, the filing fees on a utility, non-provisional, because I call it provisional utility. The non-provisional micro will be $400. That's for your basic 20 claims, 3 independents. And small T $730, and then That's a large entry's 1460. They pretty much double them each step, but it's a bargain. I mean, $400, you're getting a search and 2 patentability opinions. That on the open market's probably worth $2,500. So the patent office is giving you a deal, even though you start a business, you have a lot of other costs, but what you're getting is a good deal. And they make it up on the maintenance fees, because then you're paying money and just keeping it on the books.
There's writing the patent that is costing.
Yeah, that's the major.
Yeah. And it's like foreign language. If you read the book patent it yourself by precedent, you know not to do it yourself.
It doesn't have to be a foreign language, but you're correct. Many of us wouldn't operate on ourselves,
right.
And you can have good success being pro se, but there's a lot of extra work on your part to make sure that
it's where your time is most efficient.
And there are a lot of mistakes that you can make by doing it yourself. Now, the patent office has a lot of help will help with pro se, but we can't improve the quality of your application once it's filed. It is what it is when it reaches the office. We can work with you to get claims, understand the examination process, but we can't change what's been submitted. So once you file it, if it's not, if it doesn't meet the right requirements, there's some things we can't help with. So a lot of research. That's why we try to provide as much information up front for people. And there's a lot. If you go to our website under patents, there's a lot of information there. A lot of good resources.
I have another question. So, how many references do you guys like to see? And do you like to see the older ones? When I was doing this, it seemed like a PhD research, like literature review. It's like, do you want the original ideas, or do you want the most recent ideas, or some of each? You want no more than 10? You know, is there a rule of thumb on that?
You want to address that?
It's kind of an open standard. I mean, if you submit 1,000 references, the patent office will not be happy with that, because people have done that. And if you submit none, that's probably not good either. So it's a judgment thing. I would say in the range of 5 to 15, but really, it's the standard is, you know, is the reference material to what you're claiming in your application. So
5 to 15 really close ones.
But what's defined as really close is it's not your invention so much, it's what you're claiming in your invention.
But the reason that you provide the references to the patent office is to disclose to the office the closest prior art that's relevant to your patent application, so that they know that you're not hiding something, so that you didn't find a reference and pretend it didn't exist. I'm being somewhat simplistic here. The examiners are going to do their own searches and go find their own art, and probably are better at finding closer art than you are. But you've got a duty with the patent office to be honest in getting your patent application. So we don't want you hiding references. We don't want you claiming things that you know that you shouldn't be claiming because you saw it in an abandoned patent, but you thought maybe we wouldn't catch it. So that's the reason that you're, in addition to trying to help the examiner have a better examination by providing them references. So there's many reasons. So a long list of patents, especially patents, if you will, are not that helpful to us because we have access to all the patents. But if you found a reference in a PhD thesis at the University of Colorado that's kind of hard to find, and you're basing your patent off of that, you've got an obligation to tell us about that reference. So, those hard to find references that are really close are the ones that will doom you down the road if
Yeah, you don't want to hide one because what'll happen if you become commercially successful, your adversary will find that reference and disclose it, and if they show that you knew about it,
Your patent will die.
yeah, your patent will get invalidated because you weren't honest.
Yeah. So that's the reason. So maybe that helps you get a little bit of understanding. The patent office, the examiners don't want to see 40 pages of references, single space. They want
Academics. Don't belong.
Well, and I want to make a comment here too, that there are people who can do it pro se and can be very good at it. They're usually very detail oriented. They may have an engineering or a technical background where they know how to deal with all the details. And I'm just like coming in with all these patents that you've looked up. And I think you earlier said you have an engineering degree at least.
Two. Yeah.
Yeah. So you would probably be more likely to write a good patent than I would. My background's marketing. I'd be technical marketing, but when it comes to those tiny details, no.
I've been pro se, but that's.
But you're an engineer.
I would everyone recommend, like, if you're going to do it, I mean, in the end, seek some counsel at the, and, you know.
Yeah, that's a good one, because some people do that too, but
Shore it up with a
There are a
professional.
lot of great resources out there to help.
Yeah.
And a lot of free resources. Like I said, there's pro bono, there's help at the law school. So, you know, I